Welcome, everyone. My name is Stephanie Corsantes. I am Program Director for the International Law Student Association, ILSA, here in Washington, D.C. Thank you for joining us today. We all know memorials can be complex, especially when done for the first time. This panel is meant to solve some of the doubts that usually arise for most students while writing their memorials. Each of our panelists will first share some of their advice, and then we will begin answering questions. Many of you have already submitted your questions, so thank you for that. If you would like to ask something during the panel, you may do so on the function at the bottom of your screen, either on Facebook or on YouTube, and we will address them at the end. Joining us today is Bart Gerald, who specializes in international regulations on the utilization of outer space. He participated in 2017 and 2018 representing Poland and has been judging the Jessup since. Roxanna Nassari, she has a JD and an LLM in International and Comparative Law from Cornell Law School. She specializes in litigation at a firm in New York. She has worked for the ILSA Executive Office and as a consultant for the American Bar Association Rule of Law Initiative in the West Bank. She competed in the Jessup in 1999 and has been involved in the competition ever since as coach, judge, and administrator. She also started the European Friendly in 2014. And last but not least, we have Scott McGee. Scott is a commercial litigator from the United States located in Boston. He has been involved in the Jessup since 2005, first as a competitor, then as a coach for over a decade, and now as a judge. Our panelists are experienced and committed judges who have collectively graded more than 100 memorials only in the last year. Now, I'm going to leave you with our first panelist, Bart. So thank you for joining us, Bart.
Thanks a lot. Hi, everyone. Thanks a lot, Stephanie, for introducing me. I don't believe there's anything more to add. We were asked to give you guys a short, top 5-minute tops piece of advice on how to write memorials. Now, first of all, this will greatly vary depending on whether your university and your coaches do have prior Jessup experience. If not, however, uh, in any case, there are a few simple rules to follow. So, first of all, whenever, and I'm sorry if I will, in the meantime, touch upon some of the questions that have been asked and shared with us previously. First of all, what you need to remember when writing a memorial is that as much as the entire Jessup competition, this is a team endeavor. So there most likely won't be a single argument that will make your memorial stand out. And because of this single argument, you will win the Jessup, or you will win the national rounds, or that will be of any tremendous significance. What is evaluated in terms of Jessup is, in terms of Jessup competition and in terms of Jessup memorial writing, is how the memorial looks overall, how well it has been prepared overall, how well it has been researched, written. So what you want to strive is a certain consistency in in all of the questions that are being asked to the court. Now, what this means, and this leads me to the second point I wanted to make, is that sometimes teams do have the tendency, and I'm guilty of that just as any other just a participant, to make sure that the argument that they have drafted, that they have thought of, will be included in the final memorial, and that this will be the one that will be most pronounced. Now, as a matter of fact, that's not necessarily the case. Since this is a team endeavor, I don't believe that uh, putting too much stress or pressure on one of the points and doing everything just to include a single argument that you want to make will pay off. That's also partly because, as I have mentioned, the memorials have to remain consistent. in terms of how they are drafted, in terms of their contents, in terms of their length, on how they are researched. So even though you might have an absolutely perfect idea on how to crack the case, it may not always be the smartest move to include it, despite the fact that, for example, it might be way longer than all of the other parts, or that it would, or that you would have to sacrifice arguments that you would like to make in other parts of the memorial. Um, Last but not least, be aware that whenever you're pretty much the researching phase for writing the memorial never ends. So you might have this outlook that, okay, the problem has been published. We are doing, I don't know, month, 2 months, 3 months of research, and then the research stops, and we're just sitting merrily and writing our two memorials, submitting them, and that's it. No, that's not the case. The research never stops. It doesn't stop once the memorials are. It doesn't stop once the batches of basic materials are being published. It doesn't stop once the memorials are have their first draft, second draft. It doesn't even stop after the memorials have been submitted. So don't be alarmed, and don't expect you yourself or your team to have the memorials ready by a certain date, and then we cannot add and then have this idea that you cannot add anything because somehow the timeline would be messed up. That's actually not the case. I personally have had a situation where me and my team did include an argument, well, let's say one day before a deadline, and it still, and I do believe still that it made the overall memorial just a tiny bit better. So remember to be flexible in this respect. I believe that Roxanne and Scott will have a lot more to add to what I've just said. So just try to take away from my brief introduction. First of all, that it's a team endeavor, and you can either win or lose as a team. So try not to, let's say, have your ego take the better of you. And secondly, remember that there's not a bad time to include something that you might believe is valuable, and it doesn't matter if it's 1 day before, if it's 2 weeks before. Of course, ideally, you would like to have this very strict timeline and abide by it. However, sometimes there have sacrifices to be made. Okay, Stephanie. I think that's all from me.
Thank you so much, Bart. We had some great insights. I will remind our audience that if you have any questions you would like our panel to answer, you may do so in the function at the bottom of your screens, and we will address them at the end. Thank you. Now we have Ms. Roxana Nasari. Thank you for joining us, Roxana.
Thank you very much for inviting me to take part in the panel. So I would like a little bit to start sort of at the end in my first remark, and that would be to make sure that you leave enough time for yourselves before your submissions to check everything over and avoid any penalties. It drives me crazy every year. I've done the penalty calculations in the past for ILSA, and it drives me crazy when I see a great memorial that gets slapped with penalty points that are absolutely unnecessary. Everything at the end is going to take longer than you think. So make sure. I know Bart said you can add arguments to the end, but make sure you leave enough time to check over everything and that you've complied with all of the rules before you submit your memorials. So before you even start writing, make sure that you know what all the rules are, make sure you know what's going to incur a penalty, and make sure you avoid getting any of these. These are totally unnecessary. Make sure you're checking your word counts and following all of the other rules. Make sure you have all the parts of the memorial. Make sure you have all your page references. I know these things can seem like petty details, but they are important. And again, you don't want to be having memorial penalties, which are going to carry through with you throughout the competition. So make sure you read the rules very carefully before you get started, and then make sure that you're checking these before you submit them so that you avoid having any penalties with the memorials. I really can't emphasize that enough. It's just throwing points away. You know, if you're spending all of this time with the writing, the research, and then you end up getting penalty points. Now, I know ILSA has simplified the rules in certain respects in recent years so that certain formatting issues are no longer penalized with points. However, these can still be important when you're making an impression for the judges. So it looks very unprofessional, for example, if you're using 4 different kinds of fonts in your memorial, or if your spacing is inconsistent throughout the memorial. So make sure you're also, even if, 1 or 2 little problems are not going to be a big deal, make sure that overall the memorial presents a consistent picture. Again, these are things that are easy you don't want to be leaving the judges with a bad impression or a first bad impression when they're looking at your memorials and they're seeing the headings are all different, the spacing is all different, these things. I also would say, I know everybody wants to get as many arguments in their memorials as possible, but, don't also create, smushed words together just to avoid a higher word count. Don't invent acronyms that judges are not going to be familiar with or that are brand new just because you want to save a couple of words. Again, these are things that you want to be leaving a good impression with the judges as well. Another thing that I think creates an overall poor impression or you lose a little bit of credibility with the judges is if you write the memorial in such a way that you make reference all the time to things being obvious, extremely clear. The Jessup problems every year are drafted in such a way that these things are not extremely clear. It's not a slam dunk for either side. So make sure that you're not, of course, you're advocating for your position and you want to do so in as strong a way as possible, but still avoid language that gives the impression that there's just no contest, there's no question, you necessarily win, because that's not the way that these Jessup problems are drafted. So while you can argue and make the best arguments for your side, avoid overly strong language that suggests that there is no contest between the two sides. And those are, for me, some of the sort of global issues that you should look at and think about when you're writing, so that you're not sort of immediately giving a poor impression with the memorial. So those would be my introductory remarks. Thank you very much.
Thank you, Roxana. It's very insightful. I think we've learned a lot, especially to pay attention to those tiny details. Now we're gonna go with Mr. Scott McGee.
Hi, everyone. Thanks for having me. So I was going to first say I agree with everything that Bart and Roxana have just told you. And I wanted to focus on a couple specific things with respect to memorials. First of all, if this is your first time ever competing in the Jessup, if your university is doing this for the first time, or if you don't have examples from prior years that students from your university used in prior years to see what a memorial looks like, a really good resource to first use is just take a look at the ILSA website. If you go to the ILSA website under Jessup, there's a section called Jessup History. And each of the years, you can go back to the Jessup history, and there will be a link to the winning memorial of the Baxter Award, which is the best applicant memorial from that year and the best respondent memorial from that year. And those will be good models. You don't need to read them cover to cover, obviously, but you can see sort of the structure, you can see the formatting, the sorts of lengths of arguments that have been successful in the past, both because, as Bart was mentioning, you want to make sure you're putting forth your best arguments, curating your best arguments. As Roxanna was mentioning, you want to make sure that it looks professional and presents consistently and professionally. So that's a good place to start if you don't know what a memorial should look like. Those are going to be excellent models for you to use. And with that said, I need to emphasize, please do not plagiarize. There have been occasional instances in the past where people have found prior year's memorials on that website that have very similar legal issues and then have basically cut and paste from those. The judges who are grading memorials, a lot of times, me, Bart, Roxanna, we've read a lot of memorials in the past, and we can usually tell when something is a little bit off, and we'll be able to figure out whether there is plagiarism. So don't do that. But it is a really good model to use in order to learn what a good memorial should look like and what it should sound like. The two other points I wanted to make, one goes to the facts section, one goes to the legal argument. On the facts section, I cannot stress enough the importance of presenting the facts honestly and scrupulously. It's really easy sometimes when you're starting to make an argument for your client, which is either the applicant or respondent, whoever you're writing for. It's really easy sometimes to really want to skew the facts a little bit, or add some adjectives that aren't really justified by what's in the Jessup problem. So be absolutely meticulous about making sure that what you put in the facts section, or when you use the facts in the argument section, that you are being honest to what the problem says and not making up facts or not expanding on facts or even drawing unreasonable inferences from the facts. There's definitely a way that you can select the most important facts and address the bad facts for your case, but you want to do it honestly. With respect to the arguments, one of the things that I've noticed both as a coach when I was coaching and as a judge on any particular issue, let's say any issue in the compromise or the problem, you might be able to, after all the research you do, come up with, half a dozen, even more arguments in favor of your side on that issue. But it's important to figure out what your best arguments are, because you want to have your strongest argument and then some alternative arguments behind it that you can fall back on. So you don't want to have just one big argument that you go on for 1,500 or 2,000 words for out of your 9,500 words that you're allowed to use. But you also don't want 8 different arguments in a row, each of which only gets 2 or 3 sentences, because that's not going to be a sufficiently well-developed argument to really make your point. So as you're sitting down with your team, as Bart said, it's a team endeavor. So work with your team on this and work with your coaches. Sit down, discuss what you think the strongest legal arguments are. Sometimes you need to order them in the order of strength. Sometimes there's a logical order that you might put them in. But focus on what your strongest arguments are. Develop those arguments and include those. And just from experience, I can tell you I've had students that write 15,000 words or more and then need to cut pages. And it's a really painful process for them because they devoted so much time and effort into writing these arguments that at the end of the day, the team decides, we're not going to include because they're not high enough priority. It's a painful process to do that, but recognize that it's going to be to your benefit to curate your arguments and put your best foot forward and your best arguments forward with a couple backup arguments, but not everything that you possibly can come up with. So I'll throw it back to you, Stephanie. I think you're muted, Stephanie.
Oh, thank you. Sorry. Well, that leads us to the questions from our audiences. So I'm going to add everyone. There we go. Okay. So our first question is, what is the first thing participants should do after reading the problem? Bart, could you help us with that?
Yeah, most likely read it again. That's the first course of action. Now, why is that? Because basically, if again, as Scott and Roxana has indicated, if your university have never participated in Jessup, those problems are created without a single simple answer. So probably if you read the problem and everything is clear to you and you know who wins the case or who loses, definitely you've missed something. Second thing is that the problem is, and the problem that you are given is all the facts that will ever be in the case, providing that the corrections and clarifications will not change something drastically. So this will be the material you're going to be working throughout not only the memorial phase, but also when you will be preparing for your oral presentation, so for your pleadings. So having as much experience with it and knowing as much about the problem, basically knowing it by heart, is one of the key to success in Jessup. Of course, you can make it easier for yourself. You don't have to learn 20 something odd pages by heart because let's face it, we're not monsters. We're not going to, or very rarely, let's put it like that. Are we going to ask you, agent, please tell us what was on paragraph 22 and then expect a 100% perfect answer. However, making some sort of a list or perhaps a timeline of what happened when, and besides and on the margins of that timeline indicating what possible legal issue is here or what to check or just what does it resemble you from the things you know outside of international law might be a really really good place to start.
Thank you. Our next question is, how broad can we be when slanting the facts? Roxana, could you help us?
Sure. So again, you want to be obviously advocating for your side, but you don't want to do it in a sort of misleading manner. So, you don't, the facts are, written in such a way that some interpretations are going to be logical and others not so much. So make sure that you're not interpreting the facts in such a way that it's really not suggested by what's in the compromise. And don't necessarily totally ignore facts just because they're not good for your side. You can try to present that. I mean, you don't need to put all of this in the summary of facts. Your word count is limited there. So I would say, you want to obviously highlight the facts that are best for your position without manipulating them. So don't be, suggesting things that are clearly not in the compromise. I think a good thing would be, okay, if you think of an argument based on the facts in the compromise, there are certain things that if it was true, it would be in the compromise, so try not to just make up things that are definitely not suggested by what the facts present. Because, if it was true that, again, as we keep saying, if there was one fact that would totally, close the case, it would be in the compromise if it was like that. So, I know it's a little tricky, but, trying to, highlight the facts that are best for you without putting an unreasonable interpretation on them.
Right. So let's not exaggerate on our interpretation of facts. Scott, you were mentioning a little bit about how recommending really for, especially to teams that are doing the competition for the first time, that they should look into the ILSA page for the resources and research. So how would you explain to them what is the basic materials for and how can they use them?
So the basic materials are a collection of legal research materials that have been put together by the problem authors or others at ILSA that have contributed on the committee that sort of give everybody a good starting point. I think it's partly a recognition that not every university has the same resources necessarily. Not every university has the same history with Jessup. So, it's a good place for students to start their research. And when I worked with my students when I was coaching, what we would do is basically after reading through the problem a handful of times and having a meeting and the basic materials came out, we would just divide the pile of basic materials into 4 different sets, and each of the 4 people on the team was responsible for going through their portion. And we sort of assign those randomly. And what I'd recommend doing then is take your portion that you're going through, read it cover to cover, highlight or take notes on anything that you might think tangentially or directly relates to the problem, and then have a meeting with your team and talk through those things. As you talk through them, as you do further research, as Bart mentioned, some of the issues will become less important. You'll realize, oh my God, this case that they included from the ICJ is really central to the case, where some law review article that might be included might have, a portion that's addresses key issues in the case, but then the rest of it might not be that relevant. So I just as a practical, efficient matter, I'd say take your team members and split it up and have everybody go through their portion, and then you can talk through them and use that as a launching point for additional research, especially if you've got a law review in there that's going to have tons of footnotes to primary sources. Then you can go back and look at the primary sources that might be helpful to your case.
Thank you. It's very important to go through each and every single one of them and try to find what's really useful. And Bart, what sources or other platforms would you recommend students could use for research?
Okay, that's actually a good question. That's a really tricky question, because to everyone who's listening to us, we got the questions in the advance, and I tried remembering what sort of platforms other than providing within the Jessup subscription did I use. The only one I could come up with was JSTOR, as it did have, of course, depending on the financial abilities of your university, as JSTOR did have quite a good free plan to some of the articles. But I guess that while this is an interesting question, it's phrased in a way that might be misleading, because the writing the memorial and cracking the Jessup case and just working with it, you cannot expect to have any sort of silver bullet in one magical online source that you will just include, like in Google, how to win Jessup, and it will give you back an article that provides you with a perfect answer. So what you need to do is take whatever basic materials will be published, and then treat every single problem given to you in the Jessup case as a rabbit hole, which you have to go down with. That's basically it. You need to look at the footnotes. You need to look, how did the problem develop? Why this is even a problem? Because usually Jessup cases do concern bigger issues in public international law. Let's face it, it's not just because somebody was a fan of aquifers in 2017, but this really has been an ongoing issue in parts of the world. So the research that you're doing, why it should be legal in principle, it cannot only rely on whatever legal article you can find. You have to know what you're talking about. You have to know, or writing about. You have to know why this is an issue. You have to know a little bit of a background to it. And that's why going through the footnotes of whatever sources you have, especially the batch of basic materials, might be more rewarding than you would otherwise expect. Because whatever you will see in batch of basic materials, whatever you can read on the platforms that has been shared, did come from somewhere. This is a result of certain jurisprudence. This is a result of certain research. And to well develop your argument, you have to understand, where are those people coming from? What's the story behind? So short answer, try JSTOR. Long answer, try using every single footnote that you can and try to understand why some legal institutions and legal contracts are the way they are, what has been their history, how were they developed, because then you can write and develop a much better and much more convincing argument.
Yeah. Really, it's just keep researching and going through everything, right? All right. And Roxana, we got this question a lot. When doing research, what should we consider in order to use a judicial decision?
So I think you want to look at what is going to be persuasive for the court. So, obviously the most persuasive for the International Court of Justice is going to be other International Court of Justice decisions. Even though they are not binding on the court is obviously not interested in constantly reversing itself and issuing inconsistent decisions. So obviously, if you have an ICJ case that's relevant, you want to use that. Other international specialized tribunals are going to also be very persuasive to the court, especially if you're having specialized courts in human rights and you have a human rights issue. Things like this. So you want to look at other international decisions. Barring that, then you want to again be looking at something that's going to be persuasive for a court. If the only decision you can find that helps your case is from some state court in the United States, or some of the court decision from the lowest court in another country, that is really not going to be persuasive in front of the International Court of Justice. The case might say exactly what you want. It might be great for you, but if it's coming from the very lowest level of a judicial decision from a national court, it's really not going to get you very far in your argument. So think about things like this. You also want to be careful if you're citing, separate opinions, dissenting opinions. Those are also not usually going to be as persuasive for the court. Separate opinions, they can be useful to some extent, but make sure that you're acknowledging that and you're not acting like that's the holding of the case when you're citing something like that. So if you're citing, the very highest court of a country, that can be persuasive, but I think you want to avoid relying on, one sole judicial decision from a national court if that's your only source. But and again, you just want to think and then look at the context of the case too. It's difficult to just pluck one sentence out of a decision and say, oh, this is really helpful. You need to see, is this case overall relevant? Is it similar to the situation that's in front of us? Is this issue really what the court was addressing? Sometimes teams like to throw in footnotes, and then especially these days when the judges get these things electronically, it's very easy for them to check these references. And you don't want to be misciting or misleading in your citations. So also make sure that you really, think about the decision in its broader context when you decide whether or not it's going to be helpful to you.
Yeah, it's always tricky to find which judicial decision will actually suit you best. But if you do it consciously, I think you can achieve it. Now, and we got this question also a lot. People want to understand better how to make a connection between the law and the facts of the problem. So how would you structure a legal argument, Scott?
All right. So I'm going to start by doing what I did the first time I talked, which is refer you to the prior year's memorials. And I went through some of the older memorials, things that were sufficiently old that they were not things that anybody who might be competing this year were involved in if they competed more than once. And there are plenty of examples, but one that I've got up in front of me, if you go back to the 2015 year of Jessup and look at the memorial that won the Baxter Award for the respondents, the first argument that they make there is about non-intervention. And it is actually an extremely well-written argument. And so it's 517R from 2015. So if you're taking notes, that might be a good place to start learning, what a good argument looks like. And so the way that it's often taught in law schools is called IRAC, IRAC, the issue, the rule, application of the rule, and conclusion. And that's essentially what they do. And what I would recommend in terms of structuring an argument, even within, each sub-argument, you want to try to structure your argument as best you can using that format. And the example, if when you go look at the memorial that I mentioned, it starts out by saying, and I'm paraphrasing a little bit to keep it shorter, but respondent did not intervene in the applicant because it never extended military, logistical, economic, or financial support for the minority that was trying to secede. And that's basically your issue. That's your topic sentence. That's your issue, that the respondent did not intervene in the applicant. But then it goes on to address the law. The next step is to address the law. And it explains first what the law is sort of at a high level. What is the primary legal principle that says a breach of non-intervention involves interference with matters in each state that do not violate the principle of sovereignty. And then cites issues that say that military intervention, occupation, and furnishing assistance is something that would be intervention. So that connects it to its topic sentence, because it said we did not do those things. And that's what are those things, the financial, military, economic aid is what would constitute intervention. The next step is to then look at the legal sources. And in my view, one of the best ways to present a case is to distill the case down to one or two sentences. And in this case, the memorial referenced two particular ICJ cases, the armed activities case and the Nicaragua case, both of which are frequently seen in Jessup problems over the years. And it explains in one sentence that in the armed activities case, the court found Uganda in breach of the duty of non-intervention because it, quote, engaged in military activities against the DRC and actively extended military, logistic, economic, and financial support to irregular forces that operated within the Democratic Republic of the Congo. That is like a one-sentence distillation of that case that tells you pretty much everything you need to know about the case at a basic level. And then they turn to the Nicaragua case and say, similarly, in Nicaragua, the court found the United States had breached its duty by providing financial support, training, supply of weapons, intelligence, and logistics support to the Contra rebels in Nicaragua. What they've done there, and what you should strive to do to the extent you can, is give examples with factual summaries from other cases that you can then use to compare and contrast to the facts in this particular Jessup problem. And so in the case from 2015, they did that by saying that the applicant cannot point to any similar activities by the respondent. So there's nothing in the compromise that year that said that they provided logistical support or they provided financial support. And so they do that in contrast to the actual cases. So their application of the law, the broad legal principle, is done most effectively by comparing how the ICJ applied that legal principle to facts in other cases to the facts in that particular Jessup problem. And if you can do that what I'm going to call parallel reasoning, you're going to create a compelling argument, not just as a legal proposition, but as a logical proposition. It's going to have a logical force to it that even a non-lawyer picking up the memorial and reading it would understand, oh yeah, that makes sense. So that is sort of the way I would recommend doing it. One of the pitfalls that I see frequently in memorials is, in order to save space, teams will jump over that description of what the ICJ did in the other cases. They'll just have a very generic principle of law, a very generic description of law, with the citation sometimes to just a law review article or something that might not have that underpinning, that factual information where you can do the comparison between the facts of case A from the ICJ to the facts of the compromise or the Jessup problem. So in any circumstance where you can say, in the ICJ concluded in this case that the following facts were sufficient to show a breach or insufficient to show a breach, and in our case, the facts are similar in the following ways, that is going to be a really compelling argument. So that's your issue, that's your topic sentence. The rule, which is going to be the broad rule, explain how the rule operates through cases or through other state practice, maybe. I mean, it might not be that something has gone to a tribunal or gone to a judicial decision, but it might have gone to, the Security Council or the General Assembly or things like that, where you're going to find somewhere that somebody's analyzing whether somebody did something right or wrong, and then use the parallelism to the facts in the compromis and Jessup problem to drive the point home about why that principle results in your favor on these particular facts. And then try to do that as much as you can throughout each of the sub-arguments as you go along. So that's how I'd say the most effective way that I've seen to structure a legal argument that's going to be compelling both legally and logically.
If I would have known all this when I participated, I would have gone far. So our next question is the structure of building arguments as important as the strength of the actual argument? Could you help us, Bart?
I'll try. That's for sure. Okay, so don't be tempted to believe that when judges are grading memorials, they do have some sort of fixed table that shows points for the strength of the memorials on one side, because truth be told, there are very, very, let's say, different opinions on which arguments are strong and which are weak sometimes in the cases, depending on which judge will you ask, and the structure on the other side. However, what you have to remember is that I am yet to see a convincing and strong argument that has not been structured well. So this is not to be understood as Roxanna has indicated, you can use a judicial decision from a domestic court from, let's say, somewhere in rural Portugal, and then try to present and then structure this argument really, really well and try to pass it as a really strong argument in front of ICJ. No, that's not necessarily the case. However, if you want to develop a strong argument, you have to definitely start from the structure, because only then the strength of the argument can be presentable to the public and can be presentable to the judges. Of course, depending on the judge, we are always trying to understand the entirety of what you're trying to convey in justice. Sometimes it is not that easy. So we're doing our best to understand what you're trying to argue, what sources do you have, and assign points basing on that manner. However, I would strongly advise against trying to make a weak argument and including it just because it's structured well, or deciding that since we have a very well researched legal decision and very well researched legal issue, we can just throw it all together and don't care about the structure. Like it really doesn't work that way. It's a sort of a decision when you're going outside and you want to, well, should I wear shirt or trousers? I mean, you should wear both ideally. It's not exactly a binary choice. So yeah, I hope this helps you in a way, but just remember, I am yet to see a really, really strong legal argument in Jessup that has not been structured terribly, terribly well. You're muted, Stephanie. I'm sorry.
Thank you. That keeps happening. Now, I was saying that I have neither seen one that is not well structured. So, Roxana, which is the best way for us to use a roadmap?
So I think this ties in really well with what Bart was just saying. I mean, this, to my mind, goes very much to the structure and organization of the memorial. So I think it's, helpful when, makes it much easier for a judge to read and comprehend the structure and your arguments when you present a clear roadmap at the beginning. So, you can have a brief one at the very beginning, and then, smaller ones as you're going through the memorials. And I think, again, this is just, I know in an ideal world, judges would really, spend a lot hours on, grading each memorial and reading, every sentence over multiple times and really parsing everything. But, judges do have limited time when they're reading these. And so the simpler you can make it for them to really highlight your arguments, particularly your strongest arguments, and, make your memorial as readable as possible, the better it's going to be for you. So, again, with what Bart was saying, the better it's structured, the better, the more easy it's going to be for a judge to really comprehend what you're trying to say and to give you strong points. If a judge has to go back and forth multiple times to figure out, okay, what different arguments are here, it's a little bit the same thing with the oral argument. It's always helpful to lay out before the judges what you're going to be arguing. So, without trying to put too much emphasis on it, I would just say that this really goes to the overall clarity and organization of the memorial.
And now, when talking about the structure, the correct structure of a memorial, Bart, would you follow the order that's provided within the rules?
Yeah, most definitely I would. That first of all, I have seen very few memorials that had, for example, switched problems, and again, depending on what the current problem actually is published by ILSA, this may help you, but on the other hand, do remember that in such instance, you will be probably the only team that any judge will see that has switched, for example, the order of the questions. So you have to bear in mind that judges are accustomed to certain level of consistency in how the memorials are presented. So most definitely, I would follow in the sort of official order of the memorial and not try to reinvent the wheel. Because on the other hand, I know it's an awful answer to give, but lawyers love it for some reason, and it's the famous or infamous, it depends. But unless you have a really, really, really great reason for messing with the order of the parts of the memorial, and unless it will amount to some groundbreaking conclusion at the end, you're better off just sticking to what is already given and proven. Again, partly because it will make your life easier, because as just take what Scott has mentioned, it will be easier for you to compare the Baxter memorials to yours and see certain similarities or discrepancies, partly because you might be the only odd one out, and then the results on how judges will grade it may vary, because some judges may find it to be a terrific idea, some judges may find it to be a terrible idea, and some will just find it a nuisance because you have done something differently without any clear indication as to the reason for it.
Yeah, so read the
Sorry,
rules.
I appeared overly conservative. I'm really sorry for that.
That's all right. So Scott, what would you say are the best practices we can apply when doing citation?
All right. Best thing I can give as the number one piece of advice here is read the rules. Rule 5.13 of the Jessup rules was revised a couple years ago, and I know this because I was on the rules committee and helped talk about this and sort of raised it after reading a lot of memorials. The reason that I tell you to take a look at that rule is because there's about a half page or more of examples of here are good citations, here are bad citations. The goal of the citations, I guess, is twofold. One is, of course, to show that you actually did justify whatever legal statement you're asserting. The other one, and I think different judges use these to different degrees, is to see the strength of the authority you're relying on. Because if you have a footnote that says, citation to some ICJ decision that's famous and well accepted as customary law, versus the rural Portugal decision that Bart and Roxanna were referencing. The moment we read that citation, we need to know where the citation is from. So the idea is to be able to understand what that citation is immediately, because that helps evaluate the strength of the source that you're using. One of the years that sort of prompted the rule change, there were memorials that had, in the table of authorities, included sort of short abbreviations or short acronyms for each of the authorities, and all the footnotes just cited to those acronyms, and they were completely unusable in some cases. One was, like TC 18-12. It sounded like a droid out of Star Wars, and that's not useful because you need to understand what the actual authority is. And the teams that were doing it obviously to save word count, because word count in the footnotes do count against the word count. I saw that in the chat there that somebody had asked. So make sure that your citations are going to be clear, what the source is that you're citing. But if you have any questions or any doubt, take a look at Rule 5.13. It's got great examples, and that should give you tons of guidance, and hopefully all the guidance you need.
Yeah, it's always a little tricky. So.
Oh, sorry. Can I add one thing there, Stephanie? Yeah. The rules do technically allow you to use substantive footnotes. I personally, and I don't know how all judges think about this, I personally find that a practice that I would not encourage, just because you're working with word counts. So if you use the same number of words in a footnote as you would in the main text, it's going to be easier for the judges to read and understand by just seeing it in the main text rather than having to look down at the bottom of the page and then back up. Sorry.
Yeah. Remember, at the end of the day, I think most of the judges just want to be able to comprehend and read it, in a practical way. So I do agree with you, but that's also a personal opinion. Now, Bart, do you think the assessment of applicant memorial is connected in somehow to the assessment of the respondent memorial?
Okay, but do we mean assessment by the judges or assessment by the team itself? Because we as judges, we are, and that's a little bit of the background of judging. We are not receiving, and I don't believe we are even allowed to receive memorials for the same team to assess for applicant and respondent. So any given. So your memorials will be judged by completely separate people. There should not be any overlaps that say one person will judge both your applicant and your respondent side. So as far as it goes for judges, and you can have a 60-point respondent memorial and a 100-point applicant memorial, and no judge will be any the wiser that you did one memorial kind of, let's say during the last 5 minutes, and the other one took you 4 months. That's fine. The judges won't know. If you're, however, assessing, if you are referring to your own assessment of the applicant and of the respondent memorials, they should be connected, because ultimately you can run into an issue writing down your argument that that it sort of falls short of the consistency you would want to have with your research and with what you're claiming as the other side. And sometimes it actually prompts you to do even more research, because suddenly you end up with a situation that you think you have found the silver bullet and you crack the case, and oh my god, the respondent wins, or the applicant wins. But it's just the matter of the matter of presenting it, and not actually of somebody drafting the case with this intention in mind. So I hope I did answer the question.
Yes, you did. And these last questions have been from our audience during the panel. So our last question, Roxana, would you give us some tips maybe on how to ensure cohesion of our drafts, of the final drafts, with teamwork? How would you encourage them to work a little bit more cohesively?
If I could just add one quick comment to what Bart said before I answer that question. I would also just make sure you don't fall into the trap of thinking that, if you're the respondent, don't think that every applicant memorial that you come across is going to be like your team's applicant memorial. Some teams have the tendency of writing, well, the applicant argued this. Well, you don't know what the applicant is going to argue. You're not going against your own team in the competition. So, it's perfectly fine to say, the applicant will probably or might argue this, but don't be too defensive, particularly when you're a respondent, and just assume that you know what the applicant memorial is going to say, because trust me, after you read a lot of memorials, there are all different kinds of, arguments that an applicant is going to put in there. And a lot of them are not going to be what your applicant puts in there. So just be a little bit wary of that. Okay, as to keeping a memorial cohesive overall, I think this goes back to the point that's been raised about teamwork. Make sure that you're not just off on your own all the time, with your section. And then, just at the last minute, you decide to merge the sections and put the memorial together. Make sure that in the course of the period of time that you're writing the memorials, you're constantly having discussions and exchanging ideas with your team. I know teams structure, these things differently. Sometimes, they have in terms of who's writing what part of the memorial, but who's ever working on your memorial, make sure that you're in constant dialogue, discussion with them, to make sure for a couple of things. One, sometimes it's very, very obvious, where one person stops writing and another begins, because the style is totally and completely different. I mean, that's okay to some extent. It doesn't need to seem like it was all written by one person, but I would try to avoid a situation where one person is writing in really, really long sentences and they have, one paragraph, paragraphs of that are very short or very long, and then the other person is doing the opposite. So, make sure that before you even start writing, sit down and discuss a little bit. And to me personally, shorter sentences are better when it comes to Jessup, to make sure, again, you're getting your point across and you're not writing in huge, one sentence long, one page paragraphs. So again, just make sure you're on the same page. I think consistency is really important. So there are a couple of things. One, you should make sure you're not contradicting, a different section of the memorial. So again, make sure you're discussing these things. If you start to see a weight, because it obviously, all of these issues are connected. It can often happen that somebody, one issue might, particularly, if you're talking about alternative arguments, one issue could contradict another part. So make sure, first of all, you don't have any direct contradictions in the memorial. If there is something that there could be a tension with it, make sure you make clear if it's an alternative argument and it's, would only come into play, if part of the other argument fails. So just make sure you have a lot of dialogue and teamwork. Another thing you can do is, if let's say you're two people working on one memorial and one argument, have somebody who's working on the other side, read it through once in a while. I think it's hard to be totally objective when it's something that you've drafted yourself. So if you can have somebody else on the team read it through and tell you, oh, well, this sounds a little funny to me, or, these sections don't really work together. So again, teamwork. Make sure everybody in your team is involved. Make sure you're discussing with them. The earlier you can fix some of these issues, the better. If you wait until the last minute and then all of a sudden you try to make everything more uniform, it's going to be much harder. So the earlier, you start having regular meetings and discussions with everybody else, the better.
So one thing that I wanted to add that sort of ties into the last part of what Roxanna said about not waiting till the last minute to combine things, and also something she said earlier about leaving enough time at the end to prepare the table of authorities, table of contents, make sure all your footnotes are consistent. All that stuff will take more time than you expect it to. So please, even though you think, oh, we can just add something at the last minute, or, oh, we'll have a day to do the table of authorities, it's going to take more than a day. You're also going to run the risk, because I can tell you from when I was a student, this happened, that you might run into whoever has the master copy having their computer crash, and you don't want to run into that. So if you can store your briefs or your memorials, your drafts on the cloud, or make sure they're on multiple machines, I would highly recommend that. So definitely leave yourself enough time, more time than you expect, to finish up, do all the proofreading things at the end. And this is something that if you've got coaches who have been doing this for a while, I can almost guarantee that if you go back from this session and you tell them that I said this, they will say, yes, I agree wholeheartedly. Which brings me to, for me, my last point, especially having coached. A lot of you probably, hopefully, do have coaches that have been involved with the Jessup before. I'm sure there are some people who are coming to it fresh, or some people who have coaches that haven't participated in the Jessup before, and that's perfectly fine. But where you do have those resources, where you do have coaches that have been, writing legal arguments for a long time in their career or in their academics, or that have been especially participating in Jessup as a coach in the past, and probably a lot of them have been as judges, they know what they're talking about. So trust them. Feel free to ask them questions. They have a great amount of knowledge that will be able to help guide you. So definitely rely on your coaches. Thank them for all the hard work they do, but trust them. They know what they're talking about. There are going to be different judges who grade your memorials, and not everybody has a one single uniform approach to how they go about doing it. But a good memorial will get good scores from any sort of judge. So listen to your coaches and thank them. And I don't know, at the end of the season, buy them a present.
Thank you. Unfortunately, that's all the time we have for today. I want to thank our panelists. You have shared with us very valuable and information, and this will help many, many students. Thank you, everyone else, for joining us. My personal recommendation for participants this year is to read the rules consciously, keep working hard, and I wish you the best of luck for the 2023 Jessup competition. We will be having more training sessions as the competition develops, so stay tuned to our social media. I hope to meet as many of you here in DC for the international rounds. So have a great day or night wherever you are.
Thanks. Take care.
Thank
Thanks
you.
all.